8:45. Gives me time to take Marley to doggy day camp.
Okay, you're live, I believe.
All right. Good morning. This is Wednesday, March 10th, 2021. This is Senate Judiciary. We're taking up S3, an act relating to competency to stand trial and insanity as a defense. You have before us a redraft, draft 1.1 of the bill that has my name on it, but it really is a collaborative effort following hearing from the mother of a victim of a brutal murder in Bennington. I contacted Erica Mathage and TJ Donovan and asked them to work together on an amendment. And at one point following that work, Sarah Robinson contacted me about another issue from the Network Against Domestic Violence and Sexual Assault. And there is an amendment in draft 1.1 that's recommended by the Network Against Domestic Violence and Sexual Assault. So that's the genesis of it. I'm going to start off with Kelly Carroll, who is the mother of a victim of murder in Bennington, who tell us a little bit about her experience. And this is really what led me to talk with Erica about some of what she has seen. Erica knew the alleged perpetrator of the crime for quite a while, and has had, not knew him personally, but had a lot of contact with him. She'll explain some of the problems that she faced as a prosecutor in dealing with this man. And go ahead, Kelly. Welcome to Senate Judiciary. I'm obviously Dick Sears, your state senator, joined today by Philip Baruth, the vice chair of the committee. He represents Chittenden County. Alice Nitka, clerk of the committee. She represents Windsor County. Senator Joe Benning, longtime member of the committee from Caledonia County. And Senator White is not here right now. She's getting her COVID shot. I guess there's a HIPAA violation for me telling you that on live TV.
But a lot of HIPAA violations these days.
Yeah. So she will be with us shortly, and I'm sure she can catch up on your testimony. So thank you for joining us this morning, Kelly. And again, my condolences for your loss. Unbelievable. Go ahead if you wanted to discuss.
Thank you. Thank you. I hope you can hear me okay. I'm very nervous, so bear with me.
Well, please don't try to be as unnervous as possible. We're all
easier said than done.
I know.
Of course, there might be a time you want me to be nervous.
Yeah, Representative Morrissey is also here.
Yes, she's been fantastic, as has Erica, State's Attorney Erica Mathage. And before I get started, and I hope everyone can hear me, I want to take this opportunity to thank you, Senator Sears, and the rest of the Senate Judiciary Committee for allowing me to speak at this. I know that this is an opportunity. It's, and I know you don't like to probably talk to people like me, but I want to thank you for that. And I want to thank Peggy because she's been very, very helpful with all of my questions. Before I start, I want to let you know that my camera's on my laptop, but I've got a bigger screen over here. So if I look to the side, I'm not trying to be rude. Please don't take it that way. But I'm a really private person, and these last 7 weeks have been extremely difficult. And I know Peggy sent me the agenda, and the agenda said concerned citizen next to my name. And I guess that's true. But I think here today, I'm more here as a grieving mother. I'm a consequence of the actions of our laws and the ability of people like Darren Pronto to get away with first-degree premeditated murder without consequence. There's several disconnects between public safety and mental health, and I just want to make it perfectly clear from the get-go, I am under no circumstances advocating for taking anyone's rights away or, locking people up unnecessarily. but it's my understanding that there are top 10 or 12 most violent offenses. I'm not an attorney. I don't pretend to be. I've learned a lot. I have a lot to learn. And I think basically, you know, for me, my opportunity is to tell you what happened to my daughter. Some of the frustrations with the disconnects. And then, you know, maybe part of the solution, you know, I'm not really sure, but I'm sorry. For those of you that aren't familiar with the case, my daughter was 26 years old. She was walking through downtown Bennington at 11:15 on a Monday morning. It was Martin Luther King's Day. She was on the Riverwalk in the Bank of Bennington area, and the Bank of Bennington was closed that day because it was the holiday. There was a visiting nurse that was inside of the Walloomsac Park apartments, which is a senior housing complex that backs up to the Bank of Bennington and the local VFW, which hopefully gets open because that's a really important part of that community. And in that area, there was a woman that was doing a home health nurse. She was a nurse. She is a nurse. And she came out of that apartment building on the side and saw Darren Pronto hovering in the trees in there. And she got scared. She didn't want to walk down the walkway. So instead, she walked down the grass, the snowy grass, into the Bank of Bennington parking lot and sat in her car and called her parents because she was scared. Her parents said, call 911. So she called 911. And while she was on the phone with 911, my daughter came walking up the path. My 120-pound, 5'2" petite daughter came walking up the path. And Darren Pronto, who I have no idea who he was before this, he's a good sized guy. I think he's about 5'10", 5'11", a couple 100 pounds, stands up, was competent enough to pull up his baggy pants, ran up behind her, tackled her, slit her throat, got up, ran away, and was captured a couple 100 yards from the scene, covered in her blood, with the bloody knife. One of the Bennington police officers was responding to the nurse's 911 call, so he was right there and just happened to be in the right space at the right time. There were 2 video surveillance cameras. There ended up being a second witness. There was a third camera with still photos. And he's going to get away with premeditated first-degree murder because there is a disconnect in the law. So, like I said, I'm not a lawyer. I don't really understand all the details, but in my little layperson mind, it's my understanding that someone can go and commit a violent first-degree premeditated murder crime, and his defense attorney gets to shop around for one non-competent finding before we go to court, which is why they denied the request to have a bail hearing, and it's going right to an evidentiary hearing. So he goes and he shops around and he gets one not competent finding, not like a board of anything. You know, I mean, I think that that's something that really needs to be considered. And I know S3 has the forensic working group, and I would very, very much love to be a part of that. I know that I'm probably not qualified for it, but I would really love to participate and be part of the solution. But anyway, so he goes in, he gets this one not competent finding, and it can be anybody. He can just go right online and he can look, you know, like I can go online and I can find the same doctor to find me to certify my ostrich as a service animal, but that doesn't mean the TSA and the airlines are gonna let me take it on the plane. You know, so just because one person says that somebody is not competent doesn't mean that they should be able to get away with first-degree murder. And that's what happens. They get that before they go to the evidentiary hearing. The person goes into the custody of the Department of Mental Health. Department of Mental Health medicates, does whatever they do. And then when they feel like they're done with them, out the door he goes with no supervision and no follow-up. And I can say this because I know it happened in Pronto's case. Now, he's been in the system twice before in the state systems. And you're not going to find that in the medical records. You can't because of HIPAA. And I'm all about HIPAA. I have a healthcare background. I work in healthcare. And I get the whole importance of HIPAA and everything like that. But this is a disconnect with public safety, and this is serious. And I can't find out why he was in the mental hospital the second time. And I can't find out, you know, exactly when he got out and all of that stuff, because he's protected. But I'm going to tell you something. I found out because I found the victims. I found the other victims from the last time. So about 2 years ago, he had problems with a neighbor. One of the neighbors complained. He thought it was a different neighbor, and he went and he terrorized those people. He actually broke in threatened to slit their throats, kill their children, except the cops got there and saved them. And he went into the system and he got released with no follow-up. There's no involuntary medication order. It's my understanding that there is some medication. Again, I'm not a professional, I'm not a lawyer, I'm not a doctor, I don't pretend to be. But if there's something that can protect the public, I really think that public safety has to have some priority in the system. I don't understand how he can do this. And I'll tell you something, when you go through something like I'm going through and my family's going through, yes, you get a lot of love and support from the community, but you also find out a lot of things that you didn't really know. And Pronto made a video, he posted it on Facebook in November of 2020. So this was 2 months before he murdered my daughter. And he went ranting and raving and bragging about how he's a murderer, he can get away with it. He was laughing at our police officers. He was laughing at all of you guys because of the laws. Our laws have enabled him, they have empowered him. He has gone around he has terrorized the community. He's a domestic terrorist. He may not be political, but he's a domestic terrorist. And he has been empowered by the loopholes in the laws that the defense attorneys are capitalizing on. And it really needs to be corrected before you've got another person like me begging you to fix the disconnects. And again, I am not advocating for anybody's rights to be taken away. But when you're talking about those top 10 or 12 violent crimes, there has to be something to protect the public. And if this person goes into the custody of Department of Mental Health, there has to be something to protect the public when he comes out. There should be a notification to the victim. There should be a notification to the state's attorney, and there should be some kind of a notification to the public. And I know that that's a very hot topic with HIPAA, but you have to look at public safety. I had no idea who Darren Pronto was before all of this. And I'm going to challenge each of you to research him and see what he's done, because he's laughed at all of us. He laughs at our law enforcement, he laughs at our laws, and he gets away with it. And when he gets out this time, which he will, because it's my understanding any of these changes are not going to impact him because he'll be grandfathered under whatever else was out there. And when he gets out, I guarantee you, there will be more blood. There will be more violence. There will be more victims. There will be more bloodshed. And that's because our laws have enabled him and empowered him. And all of our legislators have to take responsibility for that. I do not know all the processes, but from my understanding, this S3 needs to get through committee. It needs to get through the floor, and then it's got to get through whatever crossover is. Like I said, I have a lot to learn. And then I realized it's going to be an uphill battle in the Senate. I know it was last year. And the only thing I can tell you is that Emily's dead. I can't bring her back, but I can be her voice, and I am going to be her voice, and I am going to continue to be her voice on this issue, because I don't consider myself a stupid person. Probably a lot of people disagree with that, but I do now consider myself uninformed. And I'm willing to bet that there are a lot of Vermonters out there like me that don't realize that we have these disconnects and don't realize how much of a danger to public safety this is going to be. And when he gets out, where's he going to live? Do you think he's going to come back to Bennington County? Or do you think maybe he's going to go up north? Maybe he'll go to Chittenden County. Maybe he'll go up to the Northeast Kingdom. Maybe he'll go and stay in Springfield. Maybe he'll come back to Southwest Vermont. But I got to tell you, wherever he goes, he's going to continue to terrorize because he can. We've allowed it. And it's just something that we need to change. So, I have a lot to learn. I've learned a lot. I've tried learning about S3. The whole thing is kind of overwhelming. When we were notified of Emily's murder, BPD and the state's attorney's office were both fabulous in the circumstances. I mean, what can you do? Except right from the get-go, we were being primed for no jail time. No jail time. This is going to be like the Elizabeth Teague case because of the laws. And I know that you all know about the Elizabeth Teague case, so I don't need to go into that. But it shouldn't be right. He shouldn't be allowed to just get out and come out and terrorize. And you're empowering other people like him. And I do not know him. And if there is a, justified mental illness, why are there so many other people out in our community that are productive, active, participants in our community? They don't go around planning his murder or murders. And he planned this. He, about 4 days beforehand, carved murder time into his dining room table or wall or something like that. Nobody called the police. For months, he was terrorizing and threatening his neighbors throughout the fall and early winter of 20, early winter of 2021. They called the state police multiple times. 2 of his neighbors had to get stalking orders, all of it because he was threatening to slit their throats, and nothing happened. The state police, there were at least 4 calls that Olivia and Jake made, 2 of which were responded to, 2 of which weren't. I haven't spoken with the other neighbors. The victim from a couple of years ago where he got out, I have a call with this afternoon. This just, you can't keep allowing it. You have the ability to keep us safe. You took an oath when you were elected. Your constituents expect it. And I'm going to do my best to be part of the solution. I've asked to join the opioid response team in town. I'm part of a small group organizing a community walk, and our first one is Saturday, March 20th at 10 a.m. at the Walloomsac Apartments, which is where the crime happened. It's not a political walk. It's geared towards bringing peace and some security back to the residents of that community. Those elderly seniors in the Walloomsac Apartments are terrified to come out of their house because of this. And again, we've empowered people like Pronto, and we need to change it. I know I'm babbling and I do apologize, but I have some questions. I want to know why he has more rights to terrorize our community than we have the right to public safety. I want to know why our laws allow DMH to release anybody at any time without notifying anybody and protecting the community. Do you want Pronto in your community? Because I don't want him back this way in mine. He's not required to medicate when he comes out. And I'll tell you, we've got a lot. I am not, one who reads all the newspapers, but if you look in the past couple of months, we've had a large increase in violence in Vermont. Up in Burlington, there's been 2 incidences involving guns and significant domestic violence and drugs. And Pronto's involves drugs. So I guess, one question is, if you take somebody who is out of their mind on crack and they commit a violent crime and we put them away with DMH and we eventually dismiss charges, because when they go into the custody of DMH, that's the normal practice, charges gets dismissed. Why is that different than somebody, that goes and drinks too much and commits vehicular manslaughter? It's not. I mean, it probably is in the sense of the legal terms and everything, but if you're going to allow somebody to take a lot of crack cocaine and then go out and kill somebody and then say, oh, I'm not competent, as a society, we're headed down a really, really bad path, because we all know that there's a significant addiction problem in Vermont. And this adds to this problem. And the more that we allow people like Pronto to use this non-competent get out of jail free card, the more we're going to have this problem. So I think that's pretty much what I wanted to say. And basically, I'm a nobody. I'm not a law enforcement officer. I'm not a mental health professional. I'm just a registered independent who says that public safety is a bipartisan issue, and you need to correct that before there's more bloodshed, because that bloodshed is going to be on everybody's hands for not addressing it. You're all elected for a purpose. You hear the problems, you see the problems, but I live the problems. My family lives the problems. Her friends live the problems. Our communities live the problems. There are people in Pownell that are petrified he's going to get out, and he's going to, and we need to fix it. So that's all I wanted to say. I really want to thank you for your time, for the opportunity to speak. And I pray that this makes its way through crossover or whatever the policy is. And should this make it to the House Judiciary Committee, I would welcome the opportunity to speak at that. I would welcome the opportunity to speak on any other pertinent issues regarding addiction, criminal justice reform, mental health services in Southwest Vermont, especially Bennington County. I want to be part of the solution, and I do thank you, and I will shut up now.
Kelly, thank you very much. Senator White from, oh God, I've got this problem again. Senator White has joined us from Windham County, and Senator White was one of the sponsors of S3, along with Senator Lyons, who chairs the Health and Welfare Committee, and Senator Clarkson from Windsor County, who's also I've got to go a different route. And Senator Clarkson is the Senate Majority Leader. We passed this bill last year, and it sat in the House. Actually, I think we passed it in 2018 before COVID hit, and it sat in the House and never got dealt with. So we're hopeful that next year, the start is this bill, but also the forensic working group, as you noted, because Vermont is unlike many states without a forensic unit that's available to the Department of Mental Health. I don't know if there's any questions for you. We did converse back and forth by email. I had not met you before, but I really appreciate your taking the time with us, but also your advocacy. One of the things that struck me in your advocacy is that you stated in one of the emails that you and I traded back and forth that it really wasn't about your daughter. You just wanted to make sure nobody else had to go through what you're going through. And I thought that was really a very courageous thing for you to say. And I know you've also got grandchildren here who have been impacted by this, and you didn't mention that. So I think the committee needs to know that your daughter also had two children, is that correct?
One. Yeah, she has an 18. He just turned 18 months.
Okay,
He's
18
in
months.
foster care.
Okay.
Yep.
Yeah. So
Yep.
I think that it's important, those things to note. And we're still a small state, and when your letter came and the background of Mr. Pronto, I contacted Erica, who's our next witness. And Erica laid out quite a long history with this man. And I think part of it is when you don't deal with problems, they get bigger and bigger. I've always likened this to, I used to run 204 Depot over on Depot Street.
Yeah.
And when we had a couch with a little bit of a hole, if we didn't fix the little hole, the kids would seem to enjoy making it bigger and bigger, and finally you had to replace the whole couch. And if you don't take care of the little things, sometimes the big things will get you. I think there's a history here of not addressing his mental illness and his violent behavior and his threats and other behaviors. So I think, are there any other questions for Kelly before we go to Erica Mathage? Thanks again, Kelly. We really appreciate the testimony.
I do want to thank you, and I do appreciate it. And I'm a realist, and I don't expect that this is going to get passed this year. And I just want you to know that it is my goal to be part of the solution, and I will be advocating for the education of the everyday Vermonter on the disconnects until we can get it through the House. So anyway, I'm going to hang on and listen if you don't mind. I would like to hear.
No, absolutely not. And I would say we're determined to get this through the Senate this year, and hopefully the House will take it up. I think there's enough here.
I would like you all to commit to that personally. I know that puts you all on the spot, but I would like you to commit to passing that.
I've got a dog in the background, obviously, who's excited. But I can't commit to what the House does. I can't.
Oh, I know.
Doing our
I
best
know.
to get out of the Senate. And that's where Representative Morrissey comes in and some other
Mhm.
folks can
Yeah.
run herd over the House.
Yeah.
Thank
So,
you.
thank you.
Thank you.
Erica, I'm gonna go shut the dog up, but if you could start, and I'll be right back.
And I apologize for being late. I had my second shot this morning and I
Yay.
just got back.
Good morning, everyone.
Morning.
So you've just heard from Kelly Carroll about the severe deficiencies in our response as a state to individuals that have the intersection of criminality and mental illness. This is not new. It's been an extremely frustrating issue for anyone that's been in law enforcement. I'm sure it's also a frustrating issue for the individuals in that work in DMH as well. It's what do we do with the individuals that have a mental illness but have also broken the law? So I think S3 is a good start. I just want to run through some of the things that Kelly testified to and how some of the changes in S3 will address those issues. The first being the notification issue. The way it is now, I think it's C1 in the bill, in the law, only requires notification for specific types of orders. And then some case law in Ray DC narrowed that even more. So it's really only that we get notification of these orders of someone being discharged if it's within the first 90 days of an order. So a couple of problems with that. When they're released on day 91 from a hospitalization, we don't get notification. When they're released on when their ONH, their order of non-hospitalization lapses, we're not notified about that. And frankly, 90 days for purposes of an order of non-hospitalization is a drop in the bucket. That's like maybe barely long enough to get an initial appointment or some initial contacts and services set up for an individual. So S3 changes that and adds C2, and that requires notification. And this is a healthy start, right? So Ms. Carroll mentioned Elizabeth Teague, and anybody who remembers that case knows it's 30 years later. So we used to get, when I first took office, I can tell you, like, the second phone call I got when I sat in that chair was from the Department of Mental Health asking me if I would agree to not fight releasing Elizabeth Teague. And I got that call every year. And Ira Morris, it was like a little inside joke. He would call me every year. What do you think this year? How about this year? And every year I would say no, because her competency was not restored. So that meant I couldn't prosecute her. I couldn't get her on any kind of supervision. And I had no information about why. I was not entitled to get any of her records indicating that she was in any way any better. The last hearing we had in that case was probably, was right before actually the law changed, which made it impossible. Then I didn't get notification anymore. They didn't need my permission. The last hearing we had, DMH made a motion to put her in a step down placement. I put on the full case, all the history, she represented herself. And I can tell you that 25 years later, she was still fixated on the same people. She was talking about the same situation that led to the homicide that she committed in Bennington in the late 80s. So to me, someone that's been in a facility for 25 to 30 years and is still talking about the people that she believed were conspiring against her and what led her to commit that murder in the first place, that's the information that the state's attorneys should have, because we are the keepers of public safety, not the Department of Mental Health. And I don't say that like as a backhanded insult. It's just not. The way the law is written, that is not their responsibility. It's not the lens that they're looking at these cases through. They are looking at, how do we treat the person? What is the best thing we can do for this person? And that's what they should do. The mistake that we made as a state, and then exacerbated it about 5 years ago, was when we made it so that the people who are in charge of public safety are shut out. We're completely left out of the room when it comes to those negotiations. So we can't have conversations with the individual mental health treatment providers. We don't even get reports. We don't get any information. And C2 in that bill at least begins that process, where now we're going to go back to, we need to be notified when someone has been charged with a crime and they are found not competent, and so the crime is essentially dismissed. We definitely need to know when they are now deemed to have a return to competency. And so what that helps us with is, A, we can notify victims. In the Pronto case, one of the emails that I found was from one of his prior assaults, where the one that Ms. Carroll spoke about was the victim contacting my victim advocate and pleading to know, where is he now? Is he being released? And the response I got from Attorney Morris at that time was, I can't tell you. And that's not okay. That's not an appropriate answer. So I think C1 is the way it currently is. Of course, that was curtailed by that Supreme Court case. But then C2 is the language that will expand that. So now we'll receive notification. And on notification, it should not be tied to offense. I know Ms. Carroll spoke of the offense that he had been, that certain offenses, or someone's charged with a certain offense. We never know, right? Which, it's really not offense driven. And a lot of the other institutions are moving away from that. We're moving away from that in the juvenile world. It's not offense driven. It's dangerousness driven. We should be looking at a risk needs responsivity. That's what we should be looking at. What does this person need? What is their level of dangerousness? And how do we protect the public without locking them up if it's not necessary? I mean, if it's an individual that can and wants to be part of an O&H, then they should be given that opportunity if that's what the Department of Mental Health and the treatment team is recommending. But the issue with the O&Hs as they stand now, we have no idea if they comply or not. A, because of the notification, but B, the O&Hs get ordered, they're 90 days long. We have no clue if they're complying or connected to services or have supports in place. The only reason I find any of those things out is if I have a pending case and I just tell the defense attorney, look, get me anything that says this person is engaged in treatment. We had one yesterday on a calendar call where a vet who suffers seriously with PTSD committed a DUI. Okay, it's DUI. I only need to worry about public safety as far as if I think he has access to a vehicle and is going to drink. But the reality was, the conversation I had with the defense attorney was all around his treatment. Is he engaged at the VA? He's become so. He's actively engaged. What I need to know is if I'm going to say this person was not competent or they were insane at the time of the offense, I need some reassurance that I'm going to be told whether they're actually complying with those orders or not. And I think that the final section of and I wrote it down, that's C3. So C3 in that section 4822 is what provides the basis for treatment providers. And typically it's the designated agency. And what's frustrating with some of the cases like Pronto was he was repeatedly on, and this was in my email to Senator Sears, Pronto was repeatedly on various conditions requiring him to engage in mental health treatment. he had a history going back, 8 years where competency had not come up as an issue. But I recognized that clearly it seemed like something was an issue with him, with his mental health. So I sent him to our treatment diversion. Just get your mental health treatment. He ended up on probation. His only conditions were engage in mental health treatment. He commits another offense, and then that's when his attorney starts arguing he's not competent. He had been, up to that point, assumed competent. There had not been a report. The defense had not requested one. So that just highlights how even here in Pronto, we were aware of the mental health issues he was having, but every single time, and he was in court probably 4 or 5 separate times where the court ordered, you need to comply with mental health conditions. Go to your designated agency, connect with them, take any, required prescriptions. And those were things that he was not doing. So I understand we went around and around with this, David and Pepper and TJ and I on the phone with what do we do with the individuals that are on an ONH? The language in C3 says, okay, now the court and the state's attorney need to be notified if they're not complying with the ONH. Well, now what? Well, the now what is we reassess whether they should continue to be on an ONH, because remember, when the court's ordering an ONH, the court is assuming that the person is going to follow these conditions and comply with them. So if they are not, we need to reassess whether they are an appropriate person for an ONH. The frustration that I think all state's attorneys have, and police, it's absolutely true and accurate. I have multiple body cameras where the defendant is yelling at the police officer, you can't do anything to me, I'm not competent. I don't know why you're wasting your time. It's frustrating. And the reason is because DMA, it's like a one-way street. They have an individual that comes into the DMH system from criminal system, and we don't know anything after that until they make their way around and we end up with them again. And this is something also that I would challenge everybody to look at. Look at your own county and try to determine if or ask your state's attorneys, how many of your officer involved shootings involve people with significant mental illness? In Bennington, it's all of them. And that's not okay either. So to have a mentally ill person in some type of crisis that we've dealt with repeatedly get shot, that's not okay either. So I think that S3 is a good start. I think ultimately I would love to see a forensic board. I completely agree with Kelly on that. I don't know if she researched it. I have spoken with some folks in mental health, the mental health field, about the structure they use in Connecticut, which would be phenomenal, but it's not necessarily expensive. It's just making sure you have a panel or a board of people sitting at the same table, really case staffing, just like we do with all of our other, like what I do a lot of with youth. What is it that this person needs? Where do they need to be? How do we balance that public safety concern with the individual rights of the person? Because someone that's mentally ill, the criminal justice system, the purpose of the criminal justice system changes. It's not about making reparations or, punishment, or it's really about what do we do to keep this person from being involved in this system and harming other people and taking someone's life, like Emily. So if anybody has any questions, but I think I hit kind of the only thing I didn't touch on, because I think it makes more sense for David to address, is the AAG, or an AAG not representing DMH. I think that the language about the state being able to get its own evaluation is obviously super important. We were completely shut down when that last Supreme Court case came out that said we can't get an independent evaluation. That's the other thing that Kelly's absolutely correct about. I have not heard anything from Pronto's defense attorney about competency. He did not ask for a court evaluation because one of the last court evaluations we had on him said that he was competent. So, and then I would have something to base my argument on. The way it stands now, I'm not going to have anything. He's going to get an expert. If he doesn't like that expert's finding, remember, he doesn't need to tell me. It's not the requirement of the state. If I get an expert and they say he's not competent, I have to share that. But it doesn't operate that way with the defense attorney. So he can shop until he finds one that has the opinion he wants, and I can't do anything about it. So I think that S3 fixes that too. So.
Thank you, Eric. I don't know if there's questions, but I want to point out while we're having this discussion, the huge majority, and I don't know what the percentage is, of folks suffering from mental illness are not in the criminal justice system. They are people
Right.
who are ill, like any other illness. We all believe that. We are talking about a luckily small subgroup of individuals who are suffering from mental illness who are a danger to themselves or others, a significant danger to other people.
Right.
They have victims. They have committed offenses, which if they were not mentally ill would be very serious offenses, such as this murder that we just heard about. But also, I mean, I just don't want people to lose sight of the fact that we are not here kind of condemning the mental health system or our Department of Mental Health. They do an outstanding job with most people. There are folks who are dangerous, who are incompetent to either stand trial or incompetent to found to be not guilty by reason of insanity. That does not mean that the offense didn't happen and that hopefully they will not continue to be a danger. But one of the things that I saw in the emails that you wrote to me that regarding Pronto case is that there was an issue of medication. Am I correct? My recollection was that he did fairly well when on medication, but once again, the issue was once he left the department, he was off the medication and self-medicating with other drugs, and that contributed to his continued violent behavior. Is that correct?
It is correct. And so one of the issues that I saw with him, and it happens a lot, is the family members are the ones that end up calling me just because I had contact with them previously on that case, or I would have one, in this case, in the Pronto case, his sister had called, not me, but she had called law enforcement when he was going through the issues with the neighbors and threatening them. And she told the neighbors, he's not on his medication. And so that's part of what I think the work group would be able to look at is what is right now. I think it's really differing. So in Bennington, we have the United Counseling Services. They're our designated agency. However, if I have anybody that's in, say, Manchester or North, Dorset, any of the areas up, I send them to, I had a man in Rupert who had been at Second Spring. He'd been hospitalized. His mother would call me regularly, at least once a week, and tell me how he was doing. He actually wrote to me from Second Spring a number of times, and not in like an awful way, because I get those letters all the time, but like just saying how things are going. His mom moved to Rutland Mental Health because he was great when he took his medication, but she was a small woman, and he had actually been injured when he was logging. So he had TBI, and then he had schizophrenia that was onset when he was in his late 20s. she called Rutland Mental Health when he was a patient, she moved him there to be a patient. All she had to do was say, I'm calling your caseworker, because what they would do is send out a team. 2 people would then come to the house, convince him to take his medication. If you don't, you're going to have to come with us. And he would always take it. She said that happened once where they had to have the individuals come to the house. And then every time after that, it was just, she would say, if you don't take it, John, I'm going to have to call. And it made it so that she could manage him. Now, I know that's not going to be the case in every case, because there's all varying levels of mental illness. What I think is missing in Vermont is the collaboration between DMH and the agencies that are responsible for public safety. I'm fine with it not being me, but let's have, it doesn't have to be a state's attorney. It could be like this forensic group that, like what they use in Connecticut, where there's a panel of individuals that are really caseworking each individual. Because again, the criminal justice system is not, we are a small state. We shouldn't be trying to treat everyone with broad sweeping strokes. We should be looking at each individual case. What are their needs? What is their risk? And then trying to figure out how we can best monitor them without curtailing their individual freedom, but to keep the public safe. Because the way it is now, we're not protecting the public.
I appreciate that. I think that's, so even as with so many other things, we don't have uniformity in the designated agencies and how they respond to various crises. And that might be part of the study here, to look at the variances in the different designated agencies. Or it's probably a better way to put it than I just gave you. Going back to my agenda. My agenda's all messed up. Are there other questions for Erica from anybody on the committee? Erica, thanks so much for your willingness to work with TJ and the state and Pepper and others to put some changes to S3 that you feel would help perhaps avoid situations. But your emphasis on the forensic working group is the right place. We need to change. And I thank you very much. All that.
You're welcome. Have a nice day, everybody.
I've got David Shear scheduled next, but do you and Pepper want to try to do a tag team here on us, or you basically have rewritten S3, and because I'm able to, I put my name on the amendment, but it's really your amendment.
Thank you, Senator. Yeah,
because obviously we can't put your names on. I want to explain that since we're live and that didn't come out right. We can't put a non-senator's name on an amendment. It has to be one member of the Senate or the entire committee or whatever. So my name is on the amendment, but you and Pepper actually, along with Erica, drafted the amendment. So Senator White.
My apologies for coming in late, but so we're not looking at S3 as it was introduced. We're looking at a rewrite.
Draft 1.1 of S3.
Okay, I have to go down and print it out because I didn't see that.
I think we can put it on the screen if you want.
No, that's okay.
That would be easier.
Unless other people want that, I can go down and print it.
Much of it is the same as S3 as introduced. It is not huge changes that, but it does address some of the things that Kelly and Erica spoke about. And I violated your HIPAA rights by telling people you were getting your COVID shot, by the way.
Oh, no, that's okay. That's okay. I just told them to. So. I'll just, I thought when you said that they rewrote S3, I figured that it was a whole different.
It is a strike all, but it contained much of what, this.
Okay.
I'll let
right.
them kind of go through it, and then we can hear from the Department of Mental Health and Jack McCullough.
Okay.
And
I'll
well,
go-
after we hear from Karen Barber, which is one little
Yep.
part of it.
Okay, thanks.
Yep. All right, maybe what you can do is start with whatever you want to do. Eric, did you want to kind of, what do you want?
Well, Senator Sears, I just wanted to ask, would you want me to put the document up on the screen while David and,
I think it might be
Pepper go-
easier for everybody to know what's changed, what's the same, and the changes that they made. Okay,
I can easily do that, and as you walk through it, David and James, just let me know when you want me to page down or whatever works.
okay, why don't we do it that way then?
Does everyone see the bill now?
Yep. Yeah, if you're
Okay.
starting, it's a strike all. And pages, until you get to page 3, there's no change, am I correct?
That's right, Senator Sears.
So maybe David, you can explain why you took the Attorney General out of.
Sure. Thank you, Senator. For the record, David Scher with the Attorney General's office. We've been, and just for the record, also the Attorney General certainly supports the amendments that have been put forward, and which will be, which State's Attorney Martha already discussed a bit, and we'll discuss a little more in a moment.
I want to make clear that I did, the conversation that I had was with both State Attorney Martha and TJ Donovan, the Attorney General, and they volunteered to work together to develop this you're presenting on behalf.
That's right. Thank you, Senator. And the Attorney General was personally involved in discussing some of these amendments. I should note that the one we're just about to discuss is not particularly substantive by comparison to the other issues that we were discussing later in the bill. This is really more of a technical issue, a procedural issue, whereby the Attorney General's office could face conflicts with itself, essentially, in instances where it would be asked to represent the Department of Mental Health and also be prosecuting a case through its criminal division. And to avoid that, we wanted to take out the statutory mandate that we be involved in these cases, that we'd be involved in representing the Department of Mental Health. That doesn't mean that it wouldn't happen. It does mean that we will continue to be involved in discussions with the department about how to make sure that the department does in fact have the representation it needs in cases. I know that those discussions are ongoing, and we believe we can resolve that issue administratively, but in order to avoid sort of forcing the AG's office into a position of conflict with itself and potentially having issues with issues of ethical responsibility, the professional ethics rules, we would ask that this provision be taken out, and we will continue to work with the department to figure out the issue of representation. Again, that's not particularly substantive with respect to the underlying really serious issues we're discussing in the bill. Unless there are any questions, we can keep scrolling down.
Yep. We're on to page 5.
Page
just
5, this
Strike out a
amendment,
whole bunch of stuff.
that's right. I mean, it's a lot of text. I wouldn't say it's really captured by one simple idea, which is that the notice provisions are no longer going to be limited by crime type. And State's Attorney Martha already discussed why this is an important change. We really need to be looking at issues of risk, not categorizing things solely by crime type. This is a change we're actually seeing all throughout our criminal codes and juvenile approach to juvenile justice as well, where we really need to be looking at what's the risk presented, what needs do people have in terms of being served, and the crime type is not necessarily an accurate stand-in for the topic of risk, and that needs to be assessed separately. And frankly, state's attorneys and the Attorney General's office needs to be able to have notice on these things, regardless of crime type, because there might be real risk issues involved that are not made apparent solely by the crime's presence on this list of very serious offenses. So all this does is mean that notice will be required for any case where a person's been committed pursuant to this section. If we want to scroll
I
on
think
down to.
Yeah, I guess I would add to that. This is James Pepper from the Department of State's Attorneys and Sheriffs. This notice provision that we're talking about which will be described on the next page, but it really, if you remember from the page up about the current law, what Erica was talking about was the way that the statute is written is that when someone's being discharged from the custody, someone who's been found incompetent is being discharged from the care and custody of the commissioner that, who's committed a crime, that they'll provide notice to the state's attorney and at least 10 days prior to that discharge. And that provision has been whittled down over time through the Supreme Court of Vermont, which just says that actually only applies to an initial order. And by the way, the initial order only can last for 90 days. And it doesn't apply when, for instance, an order is expiring. So if an order is renewed and then is expiring, the state's attorney will never know. There'll never be any bridge back to either the criminal case, or there won't be any information shared with the victim about the status of the person. So what the next change does, did the screen share stop for everyone?
Yeah,
You can't see you don't see it right now?
no, it's gone.
Oh, huh. Strange. I have it on my iPad. Well, let me try and start fresh, see if that works. Is it back?
Yep.
We're on page 6 of 11 is where
Right.
I think it went right back to where you left off, Eric.
Okay. So yeah, there was the language that Pepper was just referring to, and then
Yep.
moving on to here.
So then what this section does, which is now C2, which says when a person at least 10 days prior, and then it covers all of the scenarios that have kind of been limited by the Supreme Court. It says when a person's being kind of discharged from the care and the custody, when they're moving down from a secure to a non-secure, from an order of kind of secure residential facility to an order of non-hospitalization, when they're kind of going through the community care, so they'll be back in the community. When an order is expiring, or if the person absconds from the custody of the commissioner, then there'll be notice provided to the state's attorney, and the state's attorney will in turn notify the victim. So this is important, one, to ensure that victims know when an offender might be back in the community. Also, it's important if it's a serious crime, for instance, or the person needs, if the person has restored their competency, then the state's attorney can resume the prosecution if that's appropriate.
Just so I understand this completely, Eric, and by the way, this is what the network will be testifying against, this issue of absconding from custody on line 11. Prior to a Supreme Court decision, the state's attorney would receive notice. Is that correct?
Was that a question for Eric?
Question for anybody.
Yes, the original way that the statute was drafted in subsection C just said if someone's being discharged from the care and custody of the commissioner, that the state's attorney will receive notice and there'll be a discharge hearing. But that has been modified over time to suggest in one Supreme Court case that indeterminate period that a person could be on one of these orders is actually limited by 90 days. And then two, at which point they can the order can be renewed, but that notice provision only applies to the first 90 days.
Okay.
And then secondly, if an order is expiring, as in the Department of Department of Mental Health is not seeking to renew the order, then that's not a discharge for purposes of the statute, and so those notice provisions fall off. So this is restoring kind of what the original intent of the section was, at least what we consider the original intent, which is that the state's attorney, if someone is being released or downgraded or discharged, or the term is expiring, essentially if they've been restored, their competency has been restored, then both the victim and the state's attorney should be notified.
Okay.
I think, Eric, if you could scroll down a little bit more to, so subsection 3. So this is the part that Erica and Ms. Carroll were discussing, which is essentially when someone is not complying with one of the orders, or that an alternative treatment has not been adequate to meet the treatment needs, then both the court and the state's attorney shall be notified by the commissioner. So this is just, a lot of the orders of non-hospitalization require somewhat voluntary compliance to show up to the designated agency to take the medications. And so this is a provision that would say that if someone is not showing up to the designated agency or not complying with the terms of the order, that the court will be notified and the state will be notified. And again, what Erica described is we're not sure what the next step is, but at least it will trigger a reevaluation of the situation.
Senator Benning, but at first I want, Eric, would you let Judge Gerson know of this change so that he can comment on it when we go to markup?
Yes, absolutely.
Thank you. Senator Benning.
James, I'm not sure if this is necessarily just for you, so I hope Eric is also listening and David share as well. The notice provision here, I'm not sure how it dovetails or if it is impacted by HIPAA at all, but I'm assuming the intent is if the state is provided notice, that the state in turn would have the ability to notify the victim's family, or at least that would be understood by this, but we don't say that here. Is that something you're anticipating should happen? And if we don't have something here that authorizes that to happen, is there some interference with HIPAA?
It's interesting because the section above related to notice specifically spells out that the state's attorney shall notify the victim, and we do not have that here. So I'm not sure.
Yeah, right. That's why I asked it.
I would probably want to just, I know she's not here, but Katie McClin, legislative counsel, was the one that kind of was walking through some of our HIPAA concerns with some of these provisions. And so maybe some of the other witnesses would know whether or not this is the type of information that could be shared with a victim.
Why don't we pose that question for Katie? Eric, if you could make a note of that.
Yeah, I could also preliminarily say that I've also looked at some of the HIPAA exceptions for disclosures, and sort of a rough paraphrase, but there is an exception in HIPAA for disclosures that are required to be made by state law. So it can't be discretionary. It can't be an authorization for information to be provided. It has to be mandatory provision of information. And if the state law requires that provision, then there is an exception under HIPAA for that. So that's some background for, I'll also follow up with Katie, but.
Yeah, Eric, if the expectation of the state is that they should be sharing this with the victim, it probably ought to mirror the language above that specifically stated that.
Mm-hmm.
Yes, if that's the that's the direction the committee wants to go. I think you're exactly right, Senator Benning. It should be parallel there.
Okay. That brings us to, is there any other questions about section 3? That brings us to section 4, where I don't think there's any changes.
Yes, that's right, Senator Sears. I don't think there's any other changes at the moment.
And section 5 is the assessment of mental health services and corrections. Section 6 is the forensic working group. Is there a place here for someone like Kelly in the forensic working group? And if not, should we make sure there is?
I'll be honest, this section really is Katie's section, so I'm not
Okay.
familiar with the details.
So it can, if you, this is Jeanette, I'm reading it, it says a working group of interested stakeholders, including as appropriate, but it doesn't say exclusive to these members, so I would think that it could.
Well, I'd say
And any other interested party permitted.
victims or families of victims would be, I don't know how you put it, but that would be, I think, helpful to put in there clearly. And do they get paid if they're non? Usually we do that. I think we should probably do that here. That little line.
Yes, we should.
I mean, it's not going to be expensive, but they should at least get per diem and
Yeah.
Expenses, assuming they're traveling.
Right.
So add the per diem boilerplate.
Yeah, for
Yeah.
those that are not, the usual
Mhm.
Right.
language.
Yeah.
All right. Are there any questions for Pepper or David? I want to thank all 4 of you. One of you's not here, which is Attorney General Donovan, for the quick turnaround of this from the time that Eric and I, along with Kelly, began the conversation. It's really good. Our next witness is Sarah Robinson.
Shall I
And-
lead the statute up, Senator Sears?
I don't think you need to.
Okay.
I think the issue is victim notification when somebody, there is a letter from, on our webpage from Deborah Brookfield, who Sarah will talk a little bit about. Or is it Karen? Where's Sarah? Is Sarah with us?
Yes, she is.
Well, she's muted and not.
She's presently muted.
Yep.
Sarah, can you unmute yourself?
She can hear us.
She can hear us.
There's a letter from Deborah Brookfield, who's a rape victim, who was raped in 1989.
Sarah may have just stepped away for a moment and can't
Yeah,
hear us.
Okay, that's possible. Sounds like that's what happened. Well, I guess we could go to Jack McCullough from Vermont Legal Aid and come back to Sarah when she's with us.
Okay. Thank you. Good morning, Mr. Chairman, members of the committee. Thank you for having me here. Can you hear me okay?
Yes. We're good.
Okay, great. I've been the director of the Mental Health Law Project of Vermont Legal Aid since about 1994, 1995. We represent everybody across the state in involuntary mental health proceedings, in the family division of the Superior Court, everywhere in the state, in civil proceedings. We do not at this point represent defendants in hospitalization or other involuntary mental health proceedings in criminal proceedings. The main reason that we're interested in this bill is in section 2B on page 3 of the bill. And this provision comes out of the work of a working group the legislature created back in 2018 for relating to the treatment of criminal defendants who have mental health diagnoses. And one of the recommendations of the working group was that, or this addresses a situation when a person is either found incompetent to stand trial in the criminal case they're charged in, or they've been found not guilty by reason of insanity. And the next step in the process under either of those situations is the court holds a hospitalization hearing. And that is a hearing to determine whether the person will be required to receive involuntary mental health treatment, either in a psychiatric hospital or in some other setting pursuant to an order of non-hospitalization. And one of the things that became clear is that in those cases, the hearings, the way they are now, the defendant is represented by whoever the defense attorney is, the public defender, or the or retained counsel. The state is represented by the state's attorney's office, and the disposition of the hospitalization hearing really depends on as much as anything, on the knowledge and expertise relating to the mental health system. And so it was broadly recognized that the best way to provide the representation and provide and manage these hearings is for, once there's a determination and the person is going to be potentially hospitalized, that someone from my office, since all we do is involuntary mental health proceedings, would be the more appropriate person to represent the defendant. And similarly, the Department of Mental Health or an attorney from the Department of Mental Health would be the appropriate entity to present the arguments relating to hospitalization on the side of the state. So we support the inclusion of subsection 3B or 2B in this legislation. I mentioned to my wife last night, when I was going to be doing this, that I've been working on trying to get this through for years, and I appreciate the chair's commitment to keep working on this. One thing I should mention, and I don't think it requires a change in language, but I should bring it up. Last year, when we were working on this bill, there was some discussion about whether this provision was going to apply only to people found incompetent or not guilty because of a mental illness, or whether it would also relate to people found incompetent because of a developmental disability or intellectual disability. And I've discussed that with Nancy Bryden, who's the director of the Disability Law Project at Vermont Legal Aid. And they represent people in the cases that the members of the committee might be aware of under, I think they're called Act 64 proceedings. And what we both agreed is that it's not necessary to make this provision apply to intellectual disability cases, just mental illness cases. And I think that it's good, the way the language of the bill is drafted is probably good enough, but I just want to flag that to see if Eric or any other members of the committee think that that should be addressed before it goes to markup. And then I think the last thing I should mention is that there will, of course, it will of course not be possible for my project to handle these cases without additional staffing, and so there'll be a need for a fiscal review for this provision. And I'd be happy to answer any questions.
Senator White.
Jack, you said that in the bill, it doesn't talk about intellectual disability or developmental disability, but so you don't think it's necessary to put that in here? It was just, you were just raising the question?
Exactly.
Okay. And who was it that you spoke with that said that it didn't need to be addressed here?
Nancy Bryden, the director of our disability law project.
Okay, thank you.
You're welcome.
Other questions for Jack? Jack, thank you very much. Appreciate.
You're welcome. Thank you for having me.
Were you saying, I should ask this, I hate to ask this question. Are you suggesting that who would do the fiscal review? Joint fiscal, or are you suggesting that you have some expertise within not legal aid?
No, I think it would go to joint fiscal. The last time, a few years ago, this was in the legislature. There was a fiscal review and a fiscal note issued, and I would certainly be willing to consult with joint fiscal as they're doing that.
Okay. Thank you. Eric, do you want to just send a note to Stephanie Barrett to look at this? Along with
Yes, I can. Yep.
Thank you.
Jack, would you by any chance have that note that was done? If a fiscal note had been done a couple of years ago, would you still be able to obtain a copy?
I can try.
Yeah.
I'll look and see what I can find.
I'm using the excuse that all my documents are in Montpelier and I can't find them.
Well, yeah.
That's part of the problem.
It really is part of the problem for me, but I have access to our network even from home, so I'm optimistic.
Okay.
Great,
Thank you, Jack. Now let's pivot back to Sarah Robinson if we could. And the letter is on our website.
Yes, thank you all.
From Deborah Brookfield. Sarah, that's fine. We all do that on Zoom. This is a
Zoom troubles.
Zoom.
Exactly. Right. Good morning. For the record, Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. And I'll be brief, but I did want to highlight one small but meaningful change in the draft that you all are discussing today. And thank you, Senator Sears, for taking this testimony and also for noting the letter from Deborah Brookfield, which has been posted to the committee's website. I just wanted to say that we're broadly supportive of the bill, especially the provisions referencing victim notification. And for many years, as you all know, the state has worked to refine and improve the process for notifying victims through court proceedings and during periods when individuals are incarcerated under the custody of the Department of Corrections or on community supervision. However, as State's Attorney Marthage and others highlighted, this victim notification process has not worked well after 90 days in cases where individuals are in the custody of the Department of Mental Health, such as those that you've heard about today. So the small piece I wanted to speak to specifically is related to individuals absconding from the custody of the Commissioner of Mental Health. And so that can be found on page 6, lines 15 and 16 in the draft you are looking at. And in the letter that the committee received from Deborah Brookfield, she really outlines her stories. And in essence, when an individual absconds from the custody of the Commissioner of Mental Health, there is not notification for a victim, as there would be if an individual absconded from Department of Corrections custody. And Ms. Brookfield was not notified that the person who had violently assaulted her and threatened her life had absconded from the Department of Mental Health custody, had hitchhiked halfway across the state, and was ultimately apprehended just a mile from her home. And the way that she found out about this series of events is because the Vermont State Police put out a bulletin, a missing persons bulletin for this individual, which truly just happened to be seen by her victim's advocate. So her victim's advocate at the Department of Corrections was not notified, nor was the state's attorney, nor was obviously Ms. Brookfield. So this is it's a small change of those that you're contemplating today, but a very meaningful one. And I'd be happy to take any questions that you might have about it.
Are there any questions for Sarah? Senator White.
Thanks, Sarah. I just want to be clear. You're actually supporting the language that's in the new draft.
Very much so.
Okay, great. Thanks. That's what I thought.
It was actually her language that was inserted there that hadn't been placed in by earlier by David Scher or James Pepper. Okay, no further questions. Thank you very much, Sarah. Appreciate it.
Thank you.
Morning Fox and Karen Barber, do you want to comment on behalf of the Department of Mental Health?
Yes, thank
either
you.
one of you or both.
I think we'll do as I think this committee has gotten used to, a little tag team between the two of us. I'd like to start for the record, Morning Fox, Deputy Commissioner for the Department of Mental Health. I'd like to begin by saying, expressing my thanks to you, Mr. Chair, Senator Sears, for your comment earlier in the testimony, reminding members of this committee, as well as those of the viewing public, that the vast majority of people with mental illnesses are not the perpetrators of violent acts, and in fact are at greater risk of being on the receiving end of violent and assaultive acts. And so I just wanted to start by saying thank you for that reminder. I also would like to thank Ms. Carroll for her testimony. The experiences that she and her family have gone through, no one should ever have to even imagine, let alone actually go through. And as Ms. Carroll mentioned, around support for notifications that are described in this bill, prior to the changes that the state's attorneys and the attorney generals worked on, the department was in full support of the notifications as it was listed earlier with the listed crimes. With the expansion of that, I think it does bring some concerns to the department. And I will be asking Karen Barber to speak a little bit more in detail about that. But I just wanted to express that the change from notification from listed crimes to any crime is a bit concerning. The sheer volume that could be, and other implications could be rather significant. And I also believe that it would probably be wise to hear from Vermont Care Partners as to how this would impact their work with criminal court involved folks who end up on orders of non-hospitalization into the community. I would also like to just mention again, as Ms. Carroll mentioned, the Psychiatric Security Review Board One example being the Connecticut model is something the department has been in support of exploring for use in our state. So the forensic study group, I believe, is incredibly important. And I believe that members of this committee have heard me testify for several years now of the somewhat untenable position that the department gets placed in regards to people being committed through the criminal court system, and for the lack of a forensic facility in our state, and our ability to have people who are criminally justice involved remain in a secure setting. Since the flood of the Vermont State Hospital and the rebuilding of the Vermont Psychiatric Care Hospital and its replacement, all of our hospitals in this state are acute care hospitals, CMS certified, Joint Commission certified. And in order to continue to receive the federal participation and funding that funds the vast majority of our psychiatric hospitals, they cannot be used for public safety. And so that therein lies the rub that we struggle with, in that when a person's mental health concerns or issues have been adequately treated, that they no longer require hospitalization for psychiatric treatment, as State's Attorney Marthage mentioned, the public safety piece, our focus is to treat the individual, and we lose or face losing parts or all of our federal funding if we then restrict and keep people either hospitalized or even kept in a secure residential setting solely for a public safety perspective. There are public safety connections between mental health and law enforcement. That's clear. However, the piece that we really need to look at is what type of facility are we in need of? And I think it's also important. I think Ms. Carroll made a great point as well around people with substance abuse and substance use disorders, and I would add in developmental and intellectual disabilities as well. That because those systems have no involuntary inpatient, if you will, or secure settings, whenever there's the comorbid connection or the dual connection of mental health and addictions, mental health and developmental intellectual disabilities or traumatic brain injuries, etc., really the only recourse that the courts are really looking at is to place them into the custody of the Department of Mental Health, which is not necessarily the best services for those individuals. And again, quickly look at, does that individual need psychiatric care? And once that their psychiatric issues have been treated, then what? And so I will kind of end with that, but I think the piece that I want to stress is that we really need to look at and really study and figure out what is going to work for Vermont and such like that. But lack of those types of resources, we're going to be stuck in this position on an ongoing basis. I'll leave it at that for now, but I'll ask Karen Barber to go into a little bit more detail on some of the specifics. But just to remind folks, we're in support, and we really truly believe that we would like people to have notification when some of the individuals are being discharged from a secure setting. That's why we were in support of the original language of S3 with the listed crimes. And so I just want to make sure that we understand that, but that we do have some serious concerns of expanding it to any crime and what that impact could be.
I guess I want to make sure I'm understanding. One of the frustrations that I heard was that cases are different in different counties. So in Rutland County, somebody who's off their medications, the Rutland County Mental Health gets a call. They send out a team to talk to the person, get them back on their medication. In Bennington County, that doesn't happen. And this committee has worked tirelessly on issues of geographical justice. Seems to me like, why doesn't that happen in Bennington County? I guess those are my questions. That's one question. Understand your concern about about all of this, you know, in terms of the cost, but and if you're not responsible for public safety, who is? It starts in with this gentleman, or the alleged perpetrator of the crime that we talked about, Darren Pronto. Is charged with false information to police in February of 2015, sent to a reputable. A few months later, he's charged with domestic assault, placed on probation with mental health conditions. Supposed to be working with UCS. UCS does not share information with the state's attorney, and within months, he's violated his probation, brought back to court, given stricter probation conditions, again, focused on mental health. A year later, he violates his probation. Again, he's placed on probation with mental health conditions, requiring him to work with the designated mental health agency, UCS. He again violates again within a month, and now his defense attorneys start to argue competency. During 2018, he's admitted to the state hospital, and DMH has entered in as a party to the criminal proceedings. State's attorney's office does not receive any information from DMH. In fact, we're told we're not entitled to the information. Defendant is now found not competent, requests hospitalization hearing. DMH, intervenes. This is all 2 years before the murder. And so I guess what I'm trying to get at two things. Why don't we have a similar response in Bennington County that we have in Rutland County? And number two is, if we only look at listed crimes, then we would never see these other crimes that were committed by this person, and might have been able to catch this before it ended up in a murder. But
Can I follow
Senator
up?
White, yeah, sure.
Can I follow up on that? I think I got a little confused here, because was he determined to be incompetent to stand trial, or innocent by, or not guilty by reason of insanity in those earlier things? Because if I think I got a little confused here, because if we're talking about, there are a lot of people on ONHs that, can I finish?
Well, I was going to answer your question. Go ahead and finish.
Okay. Well, because there are a lot of people on ONHs that aren't in the criminal system. And are we talking about notifying victims whenever someone is released from an ONH, or are we talking about it only if they are in these two criminal system categories?
I'm talking about this individual. During 2018, he was admitted to the state hospital. DMH is entered as the party to the criminal proceeding. State Attorney's Office did not receive any information from DMH. In fact, we're told we're not entitled to the information. Cannot tell his victim as to at the time, anything about his whereabouts. Then the defendant is found not competent, and the State Attorney's Office requests a hospitalization hearing. DMH intervenes as a party.
Okay.
The senator would like,
I think that's,
if you'd like, I'll try to answer
please.
your questions.
Is that clear, Senator White? I mean,
Yeah. I just didn't know if the 2 years leading up to that, if he
had not been until then, until
Right.
2018. Started in
Right.
2015.
Right.
There were 3 years, and then he then they
Right,
found him not competent.
but he wasn't in one of those categories of incompetent or criminally insane before that.
No, it was 3 years
Okay.
later.
Right. Okay.
So in
Thanks.
regards to the first question, why are things different maybe at United Counseling Service versus Rutland Mental Health Service? Designated agencies historically have designed their programs independent of one another in order to meet the needs of their local communities. And so what typically works in Orleans County may not work in Rutland County, which may not work in Washington County. And so the specific of an outreach team like that may be different. There could be a lot of various reasons why that played out that way. But historically, that's part of the reason why the services are somewhat different. There are particular types of services through contracts and grants through the state, through our funding, that they're required to provide, and those are of a consistent nature. As far as, you know, the basic CRT services, emergency services, things of that nature. But how they implement different pieces of the service arrays that they have are going to vary based on their regions. And unfortunately, as far as the case that people are talking about, being part of the mental health system and being a mental health provider myself, I can't really go into the details in my knowledge of the history and treatment.
I understand that. Let me make clear. I was raising that in response to you saying that you didn't want to deal with every crime. You wanted to stick to listed crimes.
Well,
and I was showing a 3-year history there of lesser crimes.
Right.
Until he's found not competent. And then that was in 2018. In 2021, he murders or hasn't been found yet. So, the weight of evidence is great, but he is accused of murdering Miss Carroll's daughter.
And I appreciate that. I guess part of my concern, I'll stop in a second and let.
So I wasn't trying to get information about that particular case.
I
rather using that as an example of where I don't think he was accused of listed crimes.
I guess part of my concern, Senator, and I'll let Karen Barber kind of flesh this out a bit more, is we have someone who is committed based on an order of hospitalization or an order of non-hospitalization based off of a criminal offense of unlawful trespass. And part of the finalization and resolution of the case is that the charges are dismissed and they are placed on an order of non-hospitalization. And my concern would be is that individuals like that, now as the ONH is being resolved, that we notify state's attorneys that the ONH is not going to be renewed or that we're going to terminate or something of that sort, that they then will seek an order of hospitalization or contest that discharge. And how free, and I guess would that have helped us 3 years down the line? And I think that we start getting some concerns when we have folks who may be in the hospital or in a secure setting, and we have the courts making the final decision as to whether or not a person needs to remain in a certain treatment place. But I really would like Karen Barber to kind of finish up some of those thoughts.
Senator Benning has a question or comment.
Yeah, I look at this as a victim's protection bill. So for me, the Pronto matter is a no-brainer. But let me flip it to the opposite end of the spectrum for a moment. I've got a local grocery store here. It's called the White's Market. White's Market has frequent occurrences where somebody comes in shoplifting, and the shoplifter may be a repeat customer, and all of a sudden you've got a question of mental health, and the individual is given an ONH and the White's Market agrees, they're going to simply let the charges go because the person is helped. But don't they also have a right to know ahead of time, to be able to watch out for this individual that may be coming back into the store to repeat the offense?
And if they went to corrections and there was no mental health, do they have the right to know that they're coming out of corrections?
Well, if they're coming out of corrections, they would have been either as a result of a plea agreement or a conviction in a trial, been given a sentence that the victim would be aware of and would have some understanding of when they're supposed to be released. We're working on that actually in another bill, but to me, this is a victim's protection law. And when I hear you saying you're concerned about expanding, I almost have to react and say that's not the point. The point is that people have a right to be reconnected with this system and knowing ahead of time who's going to be a threat to them if they've been a threat in the past, or who potentially could be. So I guess I'm not sharing as much of a concern as you're expressing here, and Karen may have statistics or whatever to back up why that may be an additional problem for your office. But I can't really wrap my head around why we would have to limit it to a specific list of crimes, because this is not for the benefit of the person who's going into a hospitalization order. This is actually a bill for reconnecting the victims, as I understand it, to the process.
Can I follow up on that, Senator Sears?
I don't know if Morning Fox wants to respond first.
Or for Karen, just
Yeah,
to clarify what Joe said. So in the case that you were talking about, the person is a shoplifter and they're going in and they might be put on an order of non-hospitalization, but have they been actually declared incompetent to stand trial or not guilty by reason of insanity? Because those are the two things that we're talking about here. If you required every single person who moves off an ONH that has nothing to do with those two circumstances for people to be notified, that's going way beyond what this bill was intended to be, which is those two categories of people. It is, from what I understand, because the shoplifter probably was not declared incompetent nor not guilty by reason of insanity. So I think that's where we're getting confused here, because we're talking about only these two circumstances, I believe.
Yeah.
I might be totally wrong here.
No, I think you're actually right. I hate to admit that, Senator.
I know you do, but thank you for it.
It's when somebody has been declared either not competent to stand trial or not guilty by reason of insanity.
Right.
And I doubt on a shoplifting charge.
Right, I don't think so.
But Karen, did you want to comment?
Yes, I would. No worries. Thank you. For the record, Karen Barber, General Counsel of the Department of Mental Health. And so I have some comments, but I think Senator White, you touched on, I think, one of the department's big concerns and what Deputy Commissioner Fox is talking about. The way the language reads now is you omitted the section where it said it only applies to people that have been not competent or found guilty by not guilty by reason of insanity. So the language as now, which was very concerning to us, is you opened it up to everyone. And so it would have applied to that shoplifting case. If that wasn't the intent of the committee, then I think that really, I think, tailors some of our concerns, because that was one of my big concerns, is you really opened it up to a huge group of people. Did you want to say something, Eric?
All right.
I'm sorry, I was just going to note for Senator Sears that I wanted to respond to that, because that certainly wasn't the intent. I don't see that in the language, but
no,
I think it was intentionally crafted to not do that.
Right.
And
the language is, the whole bill is based upon, though, in my view, those that are found not competent to stand trial or not guilty by reason of insanity.
Great. And I think,
And one of the things that we don't have in this bill, but hopefully discussion has ensued. I've been working with Erica Mathis, John, and a couple of other people. Is there are, the effort to divert many of these cases to local mental health center or whatever to try to deal with them before court cases. So that's a major part of let's solve the problems.
yeah, and so I think kind of as a preface, we just received kind of a forwarded copy of this yesterday afternoon. So, unfortunately, the department wasn't involved in these conversations. And so maybe some of my questions and concerns are just because we weren't part of that. And so I hadn't seen the bill before. And so I'm kind of wading through and trying to understand the legal implications. So, we have comments, but certainly we could use some more time to really think about them. And it would be helpful, I guess, maybe if I could talk to Eric and Katie about some of my concerns. I think this is a tough position for DMH to be in because, obviously my heart goes out to Mrs. Kelly as a mother. I can't imagine. I think my job, though, is to kind of look at it as the legal implications and what does that mean for the department? And the department is bound by federal and state laws and regulations, which is what I'm kind of looking at when I'm going through this. I think one of the concerns I had about the broadened group, and it sounds like it's narrowed a little bit, but I still have some concerns about it because it is quite a bit broader than we had talked about before, is from a HIPAA perspective. DMH is a covered entity. We are required to comply with HIPAA, which is a federal regulation. And while there is a provision in there that if it's required by state law, but I'm not sure that's a free-for-all where we can just kind of say that a state can pass any sort of law and that HIPAA is okay with that. So I really need time to do some research and understand the implications of the new version that we just got yesterday to understand where that works with our HIPAA guidelines.
I don't have, I think it's, maybe I'm oversimplifying things, but I think it's pretty simple concept. If the courts have found somebody to be not competent to stand trial or not guilty by reason of insanity, and the state has gone all the way to that process, do victims have some right to know what's happened? And that goes back to Senator Benning's comments. We're narrowing it to that group. I believe that the intent of, and I don't see David Shearer or James Pepper here, or Erica Mathis still, but I believe, it was never our intent to go to people who might have been diverted, even, sent to diversion and, go to the local mental health center for counseling. I don't think our attempt is to get to that group. Never been my intent. Senator White.
So I'm sorry to talk so much here, but I think that when that new section is under the section 3, it's under findings and order, persons with mental illness. That section doesn't talk at all about persons who are deemed incompetent to stand trial or found not guilty because of reason of insanity. It's just anybody who is put under the jurisdiction of the commissioner of mental health, either hospitalization or none. So I think that in the rewriting here, I think that I can't see it now, but I think that part of that first paragraph that was in the original one was left off, that says it only addresses those two reasons. And I think that was left off. So the way it reads now, Eric, I think, but Eric, I can't see it, so I'm not sure.
Eric, go ahead, Eric.
Yeah, so Senator White, that section 4822 is lodged in Title 13 only. It only applies to the criminal proceedings having to do with persons found not guilty by reason of insanity or incompetent to stand trial. It's not in Title 18. It has nothing to do with the civil commitments for other persons. So I'm sure that if you hear the other attorneys who practice in this area, like Jack and Karen, they'll agree with that. And that if you look at the language on the new language on page 6, that is these new provisions about victim notification. It specifically says when a person has been committed under this
Okay.
section. So it's very specifically tied to only, because there's two, as you're pointing out, there's sort of two ways a person can become subject to DMH custody, through the criminal system and through a civil proceeding. This only applies to the folks that come in through the criminal system after a incompetency or insanity at the time of the offense finding.
And I think
Eric, I just want to add that if you go back to page 2, specifically line 11, this entire section is premised upon an individual who's been charged on information, complaint, or indictment with a criminal offense. So I'm only hearing it from a criminal proceeding, not from a civil proceeding.
Yes, that's correct.
Does that help any?
So again, previously, and when I had talked to Katie about, is there case law out there that kind of allows this kind of HIPAA exception? We were talking about a narrow set of crimes, really egregious crimes. Elopement is a new factor in there. So again, I just need time to go back and look. Again, I just got this yesterday, so I haven't had the time to really review the HIPAA implications. But
How
the
much
department
time do you
needs to
need?
make sure. I'm not sure, because I think there are a couple other issues. I'm sure if we could get a group together, I think, it's helpful when the department is at the table when these conversations happen, just so that we can kind of ask these questions in advance. But, if we could pull a group together later this week, I think that would be helpful.
Well, this is Wednesday, crossover's Friday.
Because I think when I get into the O&H issues, I think we also really need to make sure the designated agencies are at the table. It also implicates HIPAA issues, but I think one of the things that this O&H provision is doing is a couple things, right? It's taking away clinical decision-making from the DAs. Often with these criminal O&Hs, there's lots of provisions in there, many that don't tie to mental health, but are more like you can't go within a certain amount of this person, or you can't drink, because they're coming out of a criminal court. That's not really tied to mental health treatment. And there are certainly times where someone isn't complying with the exact letter of their O&H, but there's a clinical decision made that doesn't justify the revocation. But instead, the clinical team is going to work with that person, and they're going to continue. The department's goal is to have non-coercive treatment in the community. And so what this provision is doing is really flipping that on its head, and it's making the department and the DAs really more of a probation and parole function. It's taking away our ability to make clinical decisions. And it's also saying, well, okay, what's the other step? The step is to rehospitalize people. And it goes back to the problem with that. If someone doesn't meet clinical criteria, we can't hospitalize them and use Medicaid funding, right? Because as Deputy Commissioner Fox pointed out, we only have Medicaid funded hospitals. So we would be violating the conditions of our certification and accreditation and our Medicaid funding if we're admitting folks, if we're required to admit folks that don't meet this level of care. And that's kind of what this is doing. And so from a legal perspective, I think we have a lot of concerns about what this would practically mean and how this would work.
Okay, I have a lot of concerns about people being endangered by folks who are not being treated in the community, but are in the community. And folks who are coming out and the victims aren't even notified, and there's no knowledge from the victim even be on the lookout. I have a great concern about what's happening. And I think that part of the obligation, not asking the Department of Mental Health to become the Department of Corrections, but you have a forensic population that this state has not dealt with. And we keep hearing excuses why it can't be dealt with. And I think we've been talking about this for a long time. And that's what we're talking about. It's a forensic population. Again, small population. But when we hear that we can't protect communities, and I read in the newspaper that state police officers who were shot at feel that the sentence that somebody received this morning or yesterday afternoon time served in 2 years because the state's attorney was afraid that they were going to be found not competent to stand trial or not guilty by reason of insanity at the time of the shootings of state police officers. It concerns me. It concerns Vermonters, and you know that's really anyway. I would like to proceed with this tomorrow morning, but I realize that you feel like you need more time, and that's a great way to operate a business here. But we'll take it up Friday morning at 8:30.
Can I ask one more question?
Yeah, I've got a few other. Yeah, go ahead, Senator.
I realize that this only deals with insanity and incompetency, but maybe I read this entirely wrong, but on section 4822, it says if the court finds that a person is in need of treatment or a patient in need of further treatment as defined in 18 VSA 7101, and I think that's the section that says that they are a danger to themselves or others and they need to be on an ONH or a hospitalization order. And so if we're talking about all of those people here, then we are broadly expanding it. We're not just talking about, and I may be reading this wrong, but I thought that was the section that talks about defining a person who isn't necessarily involved in the criminal system, but is defined under there. So I might be entirely confused, but I do see the department's concern that this is opening it up to everybody who's on a DNH or an order of hospitalization.
I could just respond there. It doesn't do that.
Okay.
That statute sits in chapter 157 of Title 13. It's only a reference to people that are coming in through this criminal proceedings. As Senator Benning mentioned, it flows from the previous statutes. It's not referring to any of the civil proceedings under Title 18. That's the broader universe of folks that you're talking about, Senator White. I saw Jack's hand up as well. I think he probably could explain it better than I could, but
no, I understand now. Thank you.
I'd like to give time before we take a break to Kelly Carroll for a brief comment or question. Kelly was our earlier witness. My battery running low. Kelly, are you there? All right, well, why don't we?
Sorry, I wasn't able to unmute. My apologies.
Oh, okay.
Just wanted to add a comment on something that Mr. Fox said. I truly believe that this whole issue takes a multidisciplinary approach. And I just wanted to let everybody know that on Monday afternoon, I had a call with AHS Secretary Mike Smith and DMH Commissioner Sarah Squirrel, Commissioner of Corrections James Baker, and Chief Prevention Officer Monica Hutt. And Senator Sears, you had asked Mr. Fox, what was the difference between UCS and Rutland's Department of Mental Health and some of the services. And one of the things that we had talked about, most notably Commissioner Squirrel and I, was about contractor compliance. And I think that that's a big opportunity when you look at, what some of the differences are. Personally, I'm a food management contractor, and if we don't do what my clients say, we're out. And sometimes we hear it's the only game in town, they're really nice people, but I just wanted to add that, I support having, people with mental illness out in the community if they're not violent. I think we have a lot of wonderfully productive people in the community that do have mental health challenges that they deal with, and they're completely productive. And I just wanted to make sure that everybody knew I'm not advocating for them to be locked up, but contractor compliance, I think, is a big issue with some of the differences and the lack of it. And I just wanted to express that. And again, thank you very much.
I'm glad to know that that the secretary and the commissioners met with you and that hopefully it's helpful in understanding some of the challenges
I want to be part of the
the state
solution.
faces. Thank you. Jack, did anybody have a question for Kelly or comment? Jack, go ahead.
Thank you,
Briefly.
Mr. Chairman. I just wanted to respond to Senator White's question. It's true that these sections in Title 13, 4820 and 4822 do make reference to the mental health provisions of Title 18. Particularly, I think we were talking about 7101, which is the definition section. But the whole point of that reference in Title 18 was to bring in the definitions of the terms mental illness, person in need of treatment, patient in need of further treatment into the consideration for cases that involve not guilty by reason of insanity or incompetent to stand trial. As I agree with Eric that the language on lines 3 to 4 of page 6 provide that the notification provision only applies to someone who's been committed pursuant to 13 VSA section 4822. I do agree with the comment made by the department that this really does broaden possibly too far the number of cases that were involved, because Senator White, you mentioned, well, you don't think the person who's the shoplifter would have been found incompetent to stand trial or not guilty by reason of insanity. In fact, under 4822, the only way you get onto an order of hospitalization or an order of non-hospitalization is if you were found not guilty by reason of insanity or incompetent to stand trial. And it applies from everything to disorderly conduct all the way up to homicide charges. So in fact, in my experience, the largest share of people who are found who get into the involuntary mental health system through the criminal process are charged with minor and nonviolent offenses.
Thank
So I
you.
hope that you're welcome.
Yeah, I just, who else do we want to hear from on this bill? Probably Matt Valerio should be, Judge Grierson, and will mental health be ready tomorrow morning, or do you want more? How much time does mental health need? The Department of Mental Health, excuse me.
If we could have until Friday, that would be great. I think also we do need to regroup with the designated agencies. I think they are someone you should hear from, and I think certainly we're going to need to touch base with them and kind of talk through the implications for them, because we contract with them to provide.
Well, let's see if we can kill the bill. Let's see.
If it needs to be tomorrow morning, I will do my best.
No, let's, let me think about this. Can we see if we can hear from Judge Grierson and Matt Valerio tomorrow morning from 8:45 till 9:30? Peggy, we'll cancel miscellaneous judiciary bill, that's 97.
Yep.
And then schedule for 8:30 on Friday morning, S3 again to hear from mental health. And I don't have time to bring in every designated agency, and I don't think we need to. The issues raised here, yeah, well, you want to bring in the designated agencies, Karen?
I was just wondering if Vermont Care Partners might have a comment. I don't think you need to bring in all the designated agencies, but
Okay,
Vermont Care
all right,
Partners could
all
speak
right.
for them.
I completely agree. I think if
Okay,
Julie Tesler as the representative from Vermont Care Partners, I don't believe they've even seen this amendment. And so to allow them to at least speak to it, I think would be a good compromise. I don't think you need to hear from every designated agency. I think they can represent those voices.
okay, well, so we'll hear from them on Friday briefly. And Peggy, we'll work on the agenda at noontime
Sounds good.
after this meeting. So we're going to take a brief break, come back to this bill, and then take up S7 at which is the funding bill. It should be pretty close. We scheduled 11:45.
I'm sorry that we have such little time with this, but I'm also sorry that it took until the other day for a rewrite to happen, because the first time we heard that we walked through this bill was January 14th.
And, I think, we expressed that too, just learning about this amendment yesterday. In fact, the language that the Attorney General's put forward for page 3 in resolving the potential conflict of the AG's office and representing the department, to be honest, that was my suggestion. That was the department's suggestion as far as how to resolve that, because we had a collaborative conversation with the Attorney General's office. And so I'm sorry that this is mucking up the works and slowing things down right now. And I only wish that we had been a part of this conversation from the beginning when the attorney generals and state's attorneys started to work on this. And then it would have been better for us to have come in with a final package for you all today.
I'll take responsibility for that. I was trying to get something, I'm trying to juggle 14 different interest groups at one time, and I'm not a great juggler. But we do the best we can with what we've got, and meeting over Zoom obviously is not easy, and I'm sorry that the amendment didn't get to you sooner. But I might also add that we will try to hear from everybody and try to do the best we can with what we got. It's not all I can do. It wasn't directed at trying to exclude anybody.
No.
Understood. And we all are juggling a million things. And again, we're all trying to do this while we're still in the middle of a pandemic and doing things over Zoom and everything else. So it's completely understandable. And, same thing I say to my staff. We just try to work with everything and try to give everyone grace because it's tough times.
All right. So I want to, we have S25 to take up tomorrow, as well as S30. So those are and this bill are the 4 that are outstanding. So why don't we take a 15-minute break and come back at 11. Continue to discuss this amendment and other bills, and anybody who would like to join us at 11. But particularly, David, if you can work with DMH as well on the amendment, please.
We'll be ready to do that.